Hello, everyone. Welcome to this lecture on discrimination in law. This is kind of a direct continuation of the housing discrimination in the previous lecture. Discrimination in law, or de jure discrimination. I put discrimination de jure just because it makes more sense to me to read it like that instead of reading it in a Latin fashion with de jure before. Well, this is the idea that laws exist that limit the opportunities of some group or have been interrupted in such a way by the Supreme Court. Sorry, been interpreted in such a way by the Supreme Court as being discriminatory against some group specifically. The biggest examples would be like the Jim Crow laws, which led to segregation that continued after Jim Crow laws, for instance, due to racial covenants, and then, sorry, fly. And the abortion ban that just recently started taking shape, where women are no longer able to get abortions in certain states. These are instances where discrimination is just written into laws. It's obviously due to intent, the purpose being to discriminate or prohibit choice for one group of individuals. Now, the flip side of this is de facto discrimination or discrimination de facto, and that's discrimination in fact rather than in law. So the example would be a lack of wealth built up due to housing discrimination. This prevents the group, blacks in America, from having the same opportunities provided to whites because of this history of discrimination de jure, but the de facto discrimination just comes about. It just exists. It's not there to intention it. You could say it's accidental. In this case, it's not necessarily accidental, but it's just there. The discrimination's just there. You could say there's de facto discrimination if we go back to society where we're hunters and gatherers, where men have the advantage of being hunters just because um, of the genetics of the situation. The men are more apt to hunt at that time than the women, who are then forced to take on the role of caretaker. So, discrimination in law. Most lawmakers today deny the impact of de jure discrimination by minorities. But if you look obviously at the history of lawmaking, we can see there's a very evident impact. The Supreme Court has just consistently ruled in favor of police, for instance, and that's where we're really going to focus on today because, okay, season one of The Wire has to do with police and this discriminatory system. So the Supreme Court, whenever they see a case, and we're going to go through a lot of cases, they think of police as good. They say, okay, the police always have the best intention in mind, and they'll always act in that. And when the Supreme Court makes a ruling, they'll assume this, so they give cops, incidentally, more power than they otherwise should if they're abusing their power, which obviously they're abusing their power. This kind of has to do with the interpretation of the Fourth Amendment. And the Fourth Amendment was put forth to give people the rights to be secure in their own persons, houses, and effects. Essentially, you can't really search or look into and investigate someone without probable cause. So you need probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons to be seized. This doesn't just include your house. Nowadays, we think of it as just including your home. That's the only place where you're safe. You don't need where police can search you or any probable cause to search. Obviously, it's not that. Like, this includes the automobile at the beginning of this law, just walking down the street. Police don't have the right to search you unless they have probable cause. We'll talk about what was once considered probable cause and how that's weakened over time. So that's the topic of this next slide. How has this Fourth Amendment weakened over time? So across the last 2 centuries, the Fourth Amendment significantly weakened in terms of citizens' protection against police. This started with Carroll versus the United States, where police, or the ruling here, assumed that police can be trusted with determining probable cause rather than needing an objective party to determine a probable cause. So police can just come off the street and search you based on their own judgments. Their own judgments now okay, whereas before you would have needed an objective third party, which was primarily a judge. And this was allowing essentially automobile search as automobiles became more popular at this time during a police stop. So they wouldn't stop your car and then have to go get what's the word for it? Not a permit. Oh no. They need some documents from a judge to search you normally. The name escapes me though. Apologies for that. For your automobile, but then this made it so the police can just determine probable cause on their own. Now, a little bit later on, Terry versus Ohio, it effectively eliminated the need for an actual probable cause, such as like, okay, you're shooting guns out the window, or like the car's on fire, or they can clearly see like drugs or paraphernalia in the car. But now, after Terry v. Ohio, they got rid of that. Basically, you can do a search and seizure of a vehicle anytime an officer, quote unquote, feared for his life. They could search a person's for weapons, for instance. It's called now a Terry frisk. Anytime the officer claims they feared for their life, they're able to effectively search whatever property you have outside of your home. And this was motivated by a racially motivated assault on three black men in a predominantly white area. Very similar to what you saw from Hurt, Carver, and Prez, where the police obviously initiated the protocol, but the Supreme Court sided, assuming the police are good, well intentioned, that the police must have had some reason, so the laws need to be adjusted to protect the police, not the men that were assaulted by the police. So now it's very easy. If an officer fears for his life, they can search your vehicle, they can search your person. Before, okay, they couldn't do that. And it's up to the officer to determine if they fear for their life, which this is kind of in line with this next one. So these two trials here, Pennsylvania v. Mims and Maryland v. Wilson, police can order drivers and passengers out of a vehicle in order to protect the officer's safety. Again, if the officer fears for his life. And this is often exploited maliciously to, quote unquote, show suspects who's boss rather than protect safety. This is a direct quote from several sources, several police have been heard saying this. But you've also seen it in The Wire, right? Show them who's boss, get them out of the car. So the police have the right now to order you in a particular place, again, claiming they have fear for their lives. And, well, who determines if the police have fear for their life? Well, the police. The next one here, Rhode Island versus Innis, police intimidation and talking to a defendant who has invoked their Miranda rights. They've invoked their Miranda rights. It says basically, I don't have to talk to you without a lawyer. Now it's okay for the police to intimidate this person without the presence of a lawyer. So the police can intimidate a witness or a suspect even after they've invoked their Miranda rights. Right? It should be illegal to provoke them into speaking. You're not forcing them to talk. You're just intimidating them. You're talking to them. They don't have to talk back to you is the premise here. And the decision's made with the idea that this wouldn't be used to trick defendants, to trick suspects. But of course, okay, it's not the case. It's seen very clearly in The Wire. They use this to trick D'Angelo into speaking for them. They use this when they arrest Bird at some point to try and get him to speak before they give up on that and just sort of beat him up. Anyways, this is exploited all the time, and it's often used to trick defendants into getting themselves in trouble. The next law here, California versus Hoderi. You had police, they can order anyone to stop at any given point at any time now. They don't need to fear for their lives. They can just order you to stop, and you have to heed their wishes. Then the Supreme Court justification here was this direct quote from the hearing that compliance with police orders to stop should be encouraged. Only a few of those orders, we must presume, will be without adequate basis. But now, of course, okay, the police can use it to racially profile, for instance, happens quite a bit. But yeah, just to force you into stopping, you have to obey the police then when they order you to stop. Okay, fleeing is technically non-cooperation. It's a small crime. All right, so U.S. versus Drayton is next. A person has not been seized, so by the definition of the Fourth Amendment, seize, if, and this is the big one. This one's really, really, really bad. If a person, so if a reasonable person, so quote unquote reasonable person, would have felt free to leave or otherwise terminate the encounter when asked to stop and be searched by an officer. And the termination of feeling is left up to the cop that's making the order. So the cop gets to determine if a reasonable person would have felt free to leave. If the cop's like holding a gun in someone's face, sometimes they'll claim, oh, they could have just left. It was fine enough. This came about after a full passenger bus, not police, was unjustifiably stopped, and the passengers were searched and intimidated. They brought this course up to the Supreme Court, and okay, the Supreme Court ruled in favor of the police. that says it's okay to basically hold an entire bus full of people hostage as police uh, with no real probable cause other than, okay, the officer claims he fears for his life. Because in this sort of incident, a reasonable person would feel free to leave and terminate the encounter. Obviously, it doesn't happen. But yeah, this is the idea. At some point, the Fourth Amendment was actually there to essentially protect your rights to privacy. Now it's been weakened to almost just non-existent measure. The only thing that's really safe is your home. Your home can't be searched without warrants, is the documents. Ah, oh, words that escape you sometimes. So without a warrant, which is still ordered by a judge. But automobile can be searched. You on your person while you're walking downtown. All this is fair game these days. Oh, I had one more. This one, Utah versus Stariff. Evidence collected during an unjustified stop. So if the police didn't have prior cause, it was determined by maybe the defendant's lawyer. But they found evidence that's valid, then that evidence is admissible. And if you watch the sequel to The Wire, called We Own the City, you'll see many instances of this. It also gives police the opportunity to basically unjustifiedly stop someone and then plant evidence if need be. I'm not saying that happens frequently. Obviously, there's no evidence on how often that happens. There's no real data on that, but I know there's been cases where that's happened many times. And all this is going to lead to a culture of over policing and police abuse due to this additional power that they have. So over time, police have consistently used this weakening of civil rights to brutalize populations, primarily racially targeted towards blacks, or just targeted towards anyone impoverished, anyone in an area where police has sort of a reason, what is it, a reasonable reason to be, just to exert the power as a police power trip, to feel that. Excuse me. Now, there's this thing called the excessive force doctrine, which says if police actions were reasonable, given their beliefs in the situation, and that a reasonable officer would have believed the same thing. Excuse me one moment. Man. All right, so a reasonable officer would have believed the same thing in the same situation, then the action is okay. So this was like the justification that got George Floyd murdered, for instance, or Trayvon Martin was the first in BLM, where he was murdered because, okay, the ruling from the judge was that a reasonable person would have believed that they should fear for their life from this small, I can't remember how old he was, I think he was 14, um, black kid in a white hoodie who's maybe not complying to stop your order to stop that you're giving him. The idea was that the police could just shoot him because they fear for their life. And it was ruled reasonable at the time. Finally, there was a reproach on George Floyd, so that was deemed unreasonable against the excessive force doctrine. But that's one case when there are many that are erroneously sided with the police. And again, who gets to determine the reasonable here? It's the police. On top of this, if the police are in any extent biased, maybe they just didn't grow up around blacks, maybe they're just unfamiliar with people that look a certain way, so they're uncomfortable there, it can cause them to irrationally fear they're in danger when they're not. When it's obvious they're not in danger. Just because maybe they're not even racist. Maybe they just grew up in an area where they just didn't encounter blacks or like maybe someone Spanish speaking. So whenever they hear that, they get fearful because the language is a little bit more, how do you say, I guess passionate is the word, than English. So it might seem very heated when someone speaks Spanish to you, and that might motivate police action. On top of this, jurors are usually swayed to the narrative of the excessive force doctrine to believe police in trials. And why is that? Well, the jurors selected, they have to be selected because they cannot. If you have any prior prejudice against police, if you have anything that would make you act biased against the police, you can't be selected as a juror. And they also pool for racism, but they specifically select a group that's not prejudiced against police. And that actually ends up being the more binding of the selection modifiers here, because groups that are not prejudiced towards police are very specific in terms of one color versus another. Most blacks in this case, they have prejudice against the police, due to a history of unjust arrest. Even if they're erroneously arrested and they're let free, this disallows them from being a juror in a police case. The stat here, I can't remember where this came from. I think it's the Department of Labor, some federal departments. 50% of black males in the US, they would have been arrested at least once by age 30 or convicted. So this rules out 50% of black men age 30 from being jurors in police trials. So there you already have a biased population. For whites, the stat I think it's 8%. It's something ridiculously low. It's very low. And those without direct contact with police, they're going to get their information from TV, not necessarily from the news, also from any source of television. So the ones that don't actually interact with the police, they haven't been arrested or interacted with them whatsoever. The ones that are not prejudiced from police, they get their information from news or TV. And while we know that local news is very biased, one third of the time, uh, um, so it spends one third of their time on crime when you see local news. And they have a preference to show violent crime disproportionate to the actual rate it occurs. And this has increased over time. So, like in the 90s, for instance, the amount with which crime was portrayed on TV increased by 83%, even while violent crime fell massively by 20%. Huh? If I had stats for um, how much. So when you have a black that's perpetrated the crime, their name, that usually you'll see them get like an ugly photo versus the whites, it's suspect versus black's murderer or something they'll say on the TV. I thought I had the stats here. I guess they have them in a later slide deck. Anyways, this is going to cause you to get a biased juror, and oh geez, the brutality of police is predominant as police tend to over police areas. They tend to send too many police, and they tend to crack down on crime that they wouldn't crack down on in other areas. And they do this in areas that you have very high rates of crime already. And this is, of course, motivated by financial motivations for the police. It's possibly due to increasing their chances to get arrests, and those arrests can count towards promotion, which is pretty important. All the while, they're going to focus on street rips or quick sort of criminal intake rather than investigation, rather than really thinking thoroughly about this thing. And to get towards that, this surge, this doctrine, the excessive force doctrine, it allows, and the weakening of the Fourth Amendment, it allows frivolous harassment and arrests in areas, but not really comparable actions elsewhere, not really protecting areas, but it allows you to really just get into someone's face and then force them into some crime, or maybe if they just have drugs on them, search them for drugs and arrest them based on that. Now, I pull a quote here from Jay Landsman in season 2. You'll see the quote, but it's very relevant here. He's talking to McNulty about a murder that McNulty wants to investigate, or Punk wants to investigate, I can't remember who. But the idea here is that she's still dead in a zip code that doesn't fucking matter. So Jay Landsman is telling him that basically we don't investigate murders in depth in certain areas because no one really puts pressure on us to do that. So all this leads to over policing in specific areas, and it leads to ideas and statistics like this, where 50% of black men are likely to have been arrested by age 30 in the U.S. I thought I had stats on over policing here, but I think I just have the stats here. Sometimes I have stats in here that I put in and I take out because they're clunky. So in that case, they're clunky. So here I'm really going to motivate why we're watching The Wire, why The Wire is really important to this course. And the idea here is that media and culture is really, really important to lawmaking. So courts' decisions, they've historically been changed due to cultural shifts. The court has had ruling one way and then changed that over time as society has acknowledged, what's the word for it? New cultural norms. So media like The Wire is really, really important to motivate cultural shifts and awareness on certain things. And the evidence I'm going to pull for here is another group that's been discriminated against in the US, and that's gay rights. So the court's sort of rulings on gay rights here, I'm just going to outline over time. You had Bowers versus Hardwick as one of the first, where states outright banned, or they had the power to ban sexual contact, sexual contact, if desires. The states were outright allowed to ban sex for this group of people, for gays, and this was motivated to limit the spread of. Sorry, I have it here. During the peak of the AIDS epidemic, with widespread fear that gays having sex was spreading the epidemic, and it was because you weren't educating these people on safe sex at the time. You weren't educating anyone on safe sex at the time. The next, so 20 years later, they finally let gays legally have sex. So Lawrence versus Texas protected same-sex sex. It's now legal. And this came after very famous humanizing depictions of gay men and cultural acknowledgments. So you had Philadelphia, you had the Birdcage. I like to put the Dallas Buyer Club in here, but the Dallas Buyer Club came a little bit later in 2006. It's one of my favorite movies that shows predominantly LGBTQ individuals. It also focuses on the AIDS epidemic, but it came after this law, so we can't really attribute it to it. And finally, you had oh man, I can't pronounce this name. Obergefell and versus Hodge, which legalized same-sex marriage across the whole U.S. So okay, they were allowed to have sex in the beginning of 2000s. That's great. And well, another 15 years later, they were allowed to finally get married. And marriage comes with a lot of benefits, a lot of tax benefits, but then a lot of security as well, just because you're married. People look at you differently. And you can tell at this point in 2015, right, culture had just fully come around to completely accept gays, with lots and lots of examples of gays depicted not as a niche or anything, but just as a norm in media. Ellen had a big, man, has she been canceled for sexual harassment? I don't know. Anyways, I grew up with her show, so it's a very famous show. So Ellen, very famous, and she had a really, really, really popular TV show. Buffy the Vampire Slayer was one of the first to show lesbian couples, along with The Wire. I think Buffy was slightly before. The Wire, of course, has Omar and Kima, who are depicted as very strong characters, strong gay characters, and Will and Grace is another example. Like I could name several shows here. I just sort of named a set of my favorite or a set of I found most culturally influencing. So media plays a large role. Media and culture plays a large role in terms of how do laws actually change? And we're seeing that now as the Black Lives Matter movement eventually got traction. It took them 8 years to get to that point. And now we're seeing the Supreme Court, courts generally just ruling more in favor of black defendants or the ones that have been killed, ruling against police brutality. Now we're going to talk about the habits of police. So earlier in the season, we saw that D was attempting to root out skimmers in his group and his crew. The question here then is do police skim? Do police also kind of steal off the top? And the answer is sure. They do it in many ways, and we've seen many ways so far in The Wire. They can do it by exaggerating injury to get early pensions, which come at the expense of taxpayers. You see Herc and Carver get accused in these episodes of stealing money from an arrest that they made, or sorry, a seizure that they made of property. And they're accused of it because it's prominent at this time that police will kind of skim off the top and steal money that they've seized from individuals. So that's why they were accused. They didn't do it in that case, but have police prominently stealing at that point. And what about some other ways in which police skim in The Wire? How are they skimming off of their employer, which is the government, and also to a large extent taxpayers? What are some ways? Just think about that for a moment here. So the first is claiming overtime unnecessarily, which happens quite a bit. Police will claim overtime, which gets them a huge increase in pay. So when it's not necessary, okay, that's stealing. It's maybe not legally stealing, or maybe no one's getting in trouble for it, but it's stealing. It's skimming for sure. Slacking on the job, so you're hired to do a job, but you'll see a lot of police sort of just sitting back and doing nothing, not really doing any work. Santiago is this case, the two older police in the wire detail are doing this. Sorry, weird noise in the background. Um, you also know, or you should know, that as a result of the action taken against police from those that were involved in the Black Lives Matter movements, murders, police stopped working even more. So they started slacking even more. There were far fewer arrests made as a result of that action because police were using it as an excuse to basically not go in the streets and not really do their jobs. On top of this, you have cooking the books, creative accounting, misrepresenting maybe money taken in, or misrepresenting their own work hours if they're on patrol. All this happens. On top of this, we see commonly the Barksdale crew lie to get themselves out of trouble in the courtroom as well as to each other. But do the police do the same? Do they lie? Are they purely innocent here? And when they do they get out of trouble? And the example here is, of course, Prez Hurricane Carver lying to get out of trouble with the raid on the wire. If police do some action that is negligent or an issue, they can basically lie and then have that story supported by reliable sources, which are other police. And of course, you mentioned all the laws that give police all the advantages in the courtroom in legal defense, which is where we're going to come to. Now, that's not the end of the story because legal defense is a two-sided affair. You have a persecutor and a prosecutor, rather, and a defendant. So the Barksdale crew, their lawyer, Levy, he doesn't satisfy so in the wire we're talking about, Levy doesn't satisfy the conditions for a lawyer for the full cartel. And this is a common practice for drug cartels to have a single lawyer that handles all of their business. It's very common in real life. Now, the reason that Levy isn't a satisfactory lawyer for the full cartel is that he doesn't act in the best interest of the pawns of the cartel. He only acts in the overall organization's interest. So if he's some individual, like if he's Bird's lawyer in a trial, he's not acting in Bird's best defense. He's acting in his own or the organization's own interest. So he could convince Bird to take a charge if it's going to protect the people above him. And in a way, this is going to limit climbing the organizational ladder. So think about how it can do that just for a moment here, and then I'll sort of explain it. Okay. So the idea is, okay, the people at the top are really well protected because they're in the organization's interest. They're the ones that pay lawyers like Levy. The people that maybe are aspiring to get to the top, they could be forced to take a charge in a given moment to protect the people above them. So it prevents climbing the ladder to a large extent. Keeps people at top on top. And is this a discriminatory system? Yes, it is, because the rich, in this case, stay rich, and the poor can't succeed. So you'll see, not you'll see in the wire, but the idea is like someone like Avon, or, well, I guess you will see, Avon's family has been in power for a long time, and they're able to keep this power because of this sort of system that no one can really easily get up to the point where they could challenge him for power because he has all the power and the connections. And the lawyer that works for everyone else, okay, he also works for Avon, and Avon's the big guy in charge. Now, the alternative here for a lawyer like Levy is a public defender. But public defenders in Baltimore, especially, are just massively overburdened. So, on average, they're assigned 473 cases per individual lawyer per year. So that's more than twice the state's recommended caseload for how much you should be able to do as a maximum, and it's more than one case a day, right? And it's unbelievable amounts of work that you have to do to put in to do well on the case. So public defenders are just unbelievably overworked to a large extent. And the idea is, can a public defender really keep defendants out of jail with this sort of split attention if they have to focus on more than one case per day? And there's no way. It's likely a driver of high conviction rates and prison overpopulations for low income because they're forced to work with public defenders who are just massively overburdened, and no one's really putting in more tax money because lawyers are really, really expensive to begin with to hire more of these groups. On top of this, public defenders get paid around the worst of any other type of lawyer. So there's little incentive to have new public defenders, which exacerbates the problem. Now, that's the end of slides I have that are really not, what's the word for it? Not unique to the university I'm teaching at. I have research and writing slides for the rest of it, so I'm going to skip through these. They're just my recommendations for writing, organization, and the like. And we're just going to get to the discussion questions here. Okay. First discussion question, most important one. Kima, shocked, really, really rough, and everyone has an emotional reaction to it. The discussion here is why do blacks and white cops get different duties? Why are they treated differently? So think about that. Talk about it amongst yourselves, and then answer to me if it's fair or not. Is this different treatment fair? Could you have sent or should you have sent Orlando in the car with McNulty? And okay, obviously the answer is no because there's no way you can convince the group that he's working with that this white guy is not a cop. You have to have someone with a probable disguise. The second discussion question here is okay, the Barksdale crew, they're putting out testers of new drugs. And drugs are experience goods. They're classified, a class of goods where we don't know the value of the good until we try it, until you try it. So these testers that they put out, they help with consumer uncertainty. And the question is this a good marketing strategy for the group? Are there other benefits that come with it beyond giving the individuals a taste for the good or a taste for the quality of the good? And then finally, here we have police are set up to arrest very novice drug dealers, non-established practitioners who are very smart and avoid them like the Barksdale crew. Is this what's the effect of this? How could this be modeled as a discriminatory system, something that feeds back and keeps the rich rich and hurts the poor in the area? And that's all I have for today. So I will see you guys in the next lecture. As I mentioned, this one's a little bit short just because, okay, we have so much content that's really specific to my students. Anyways, and I'm not going to read any essays from you guys online, unfortunately. So have a good day. I'll see you guys in the next lecture.